All right, so we'll be talking about property law today, starting with intellectual property. And then we'll go to real property and personal property in chapter 14. So intellectual property, trademarks, copyright, patent, industrial designs. Can you give me an example of any IP you know? Logos? Okay, yes, logos. I see logos. I see an Apple logo. I see Asus work. Is it work? I see another Apple there. I see HP back there. Yeah, I see logos. So logos, they help me identify which product or which company, which manufacturer they are. Do you know how much the Coca-Cola brand, just the trademark, just the brand, is worth? Billions. It's around 50 billion. 50 billions. Just the trademark. Not talking about the Coke, the pop itself. I'm not talking about premises. I'm not talking about machinery. Just the brand. The most valuable brand in the world. Google, Amazon, Apple, they've been fighting for the first place. Over $200 billion worth. Okay, so this is all possible because of IP, because of intellectual property. So today, my main objective with you is to help you from now on, to help you differentiate what copyright protects, what patent protects, what trademark protects, and what industrial design protects. There's a misconception in which people believe that most things are protected by patent only. Oh, I have this idea, I will not disclose with you because I want to patent it before. Well, it depends on what your idea is about. What if you have an idea about a book? A book cannot be patented. What if you have an idea about a performance, a theater performance? Again, not protected by patent. So if by the end of the lecture today, you're able to differentiate the various subject matters that are protected by each, I'll be happy. Okay, it's important to understand the very different subject matters that are protected by each type of intellectual property. But first of all, what is intellectual property? Well, it is a part, a subcategory of property law, subcategory of an intangible personal property. Intangible because we cannot touch. They are rights. So when I have a patent, I have a right over a discovery, over an invention. When I have a trademark, registered trademark, I have rights, exclusive rights over the brand, the logo, the slogan, etc. So that's why they are intangible. And they refer to ideas, but also to information and creative works. So that's why there are these different types of IP, because each will protect different types of works, creations, etc. The purpose of intellectual property law is to protect the product of mental effort. So whatever is created, invented, the idea of the law is to protect the product, to protect the creation. Why would I invest millions of dollars? Why would pharmaceutical companies invest millions of dollars if they could not protect their discoveries? And others as well. And also another purpose, as important as the first one, is to encourage the free flow of new ideas. Well, I have spent money, I have spent time, I created something, now I have protected. Now I'll make it available to the public in general. What if I had a, would I be incentivized to invest creating a vaccine if I make the vaccine available but not protected? And because it is protected, now we can make it available to the public. That's how it works. In Canada, IP, intellectual property, is governed by federal legislation, federal laws. So we have the Copyright Act, we have Patent Act, we have the Trademark Act, Industrial Design Act. So it's all federal legislation. In other words, there's one law applicable everywhere in the country. It's not provincial legislation. So let's start looking at this. There are more types of IP, but the four main ones, or the four that we'll be focusing on today, will be copyright, patents, trademarks, and industrial design. And we'll also be talking about confidential information, trade secrets by the end. So first of all, copyright. What does copyright protect? It protects all types of works that are literary or dramatic or musical or artistic, even performances, sound recordings, communication signals. In other words, I'm saying that articles, postings, books, even computer software, they are protected by copyright. So we don't say a book will be patented or a patent protects a book. No, we say a book is protected by copyright. The same applies for movies, videos, television, etc. Musical compositions, paintings, drawings, maps, pictures, photographs. They are all protected by copyright. A website protected by copyright. So from now on, do not make this mistake. Oh, I want to patent this. Okay, the subject matter may be patented, but if it is one of these, it's not about patent, it's about copyright. Okay, so you should know what copyright protects. And it's important to know also that only the actual work is protected, not the idea. So if I have an idea about a book, the idea is not protected. Only the book itself. Only after I write the book, after I draft the book, it is protected. If I have an idea about a picture, the idea is not protected by copyright. But after I take the picture, it is protected. So it's only the physical embodiment of the work itself. Does it make sense? So idea of a software is not protected. The software itself, after you write the code, it is protected. Okay? And then how long is it protected for? 70 years. Please take note of this because your textbook is not updated. This just changed January this year. Your textbook may be reading 50 years, but it's now 70. 70 years after the author's death. That's why most of Disney characters are still protected by copyright. Well, it's 70 years in Canada. Coincidentally, it's also 70 years in the US. So countries will have different time length. Okay? So protection 70 years after the death of the author. And after expiration, after the author dies, after 70 years of the author's death, it expires. When it expires, we say it goes to public domain. In public domain, anyone can use it without the need to ask for the author's authorization. Okay? You can Google public domain photos, public domain books, public domain performances. Most of Shakespeare's plays, they are already in public domain because it's been over 100 years. Are we good so far? So you know what copyright protects. You know that only the actual work is protected, and you know it is protected for 70 years after the creator, the author's death. It's quite long. Okay. What else? Creation of copyright is automatic in Canada. In other words, you don't need to apply for protection. You don't need to file. All you need is to create. So once you take a picture, that is protected automatically. Okay? No need to register, no need to apply. There is registration of copyright, but registration of copyright is optional. You spend about $70, $80 if you want to register with a copyright office in Canada. Well, if it's not needed for protection, why would you register? There could be two reasons. First, if you register, you would have a public record of your creation. So you create it, you send for registration. So if needed be in court or any other dispute, you would have a public record of your creation. Second, registered copyright. They are also protected internationally. Well, initially, all types of IP, they are only protected in the country they were either created or granted. The same applies for copyright. If I take a picture now, it is protected only in Canada, not in the US, not in Mexico, not in Brazil, not anywhere else, only in the country. However, there are international conventions, international agreements that change the situation. One is the Berne Convention. You don't need to know the name, but you need to know that the Berne Convention allows for protection of copyright internationally. As long as your copyright in the country you created is registered. So it's beneficial to have it registered because you have international protection. Are you following? All right, now, let's say I work as a software developer. I am being paid to develop software. I'm using my employer's resources. Do you think the copyright I create should belong to me or to my employer? Employer, because I'm being paid to do this. I'm using their resources. So yes, you're right. Unless the employment agreement says otherwise, any copyright created in the course of employment belongs to the employer. So as an employee, if you want to own the copyright, then you need to have an express clause in the employment agreement. Okay, because in silence, it will belong to the employer. All right, now with regards to the rights, when I own copyright, let's say I have come up with a textbook. I wrote a textbook, a law textbook. So I have two types of rights. I have the economic rights and I have the moral rights. Economic rights to make money out of my copyright. So I can sell my economic rights. I can license to a publisher because I cannot afford to publish a textbook nationwide. However, moral rights, what is a moral right? The moral right is the right to have my name associated with my creation. It is the right to have my name not jeopardized by anyone else. So my moral rights, they still belong to me. Even after I license, even after I sell my economic rights. Okay? I may waive my moral rights. I may, if I want, but I cannot sell my moral rights. I can sell, I can license my economic rights. Are we good? All right. So now, exception to infringement of copyright. Okay, so let's think about a song. Let's think about Justin Bieber's song. Can you use that song in a YouTube video? No, you cannot, unless you have the authorization, unless you pay fees, etc. So this is infringement, this is violation. When we use, distribute, sell without authorization, and mainly when we make money. If you have a textbook and you have it copied, is this infringement of copyright? When you make a copy of a full textbook? Yes, it is, because it's for sale. And you are violating rights of the publisher, of the author. But there's an exception to this. The exception, one of them is the fair dealing. If you use copyright content in a fair way, not in an extensive way, and mainly for education, for satire, for private study, news reporting, criticism, you are not violating. Let's say you have a YouTube channel and you want to make a review, you want to criticize, you want to make a satire about Justin Bieber's song. You can do it. It's not a violation. You are not playing the song in a way to promote the song, but you are criticizing, you're reviewing. Or maybe if you want to have a part of the song to your study because you study music, let's say. This is possible. Your intention is to study, to research, to review, to critique, not to promote the copyrighted content. So this would be fair dealing. This would not be a violation. Are we good? All right. So now, infringement, I just said what it is. Infringement is violation. So it is when someone benefits from either selling, distributing, reproducing, or any other commercial use. Or even when you claim you are the author. When you say that concept, that wording is yours, plagiarism. Those are all violations. How do we avoid plagiarism? How can you avoid plagiarism? Speak loudly. Citation, citing. Remember, here, it's fair dealing if we use for education, for private study, for research. So if you have to write an article about something, and there's this author or these several authors that have written about the subject matter you're talking about, you can use their thoughts, their statements, but you have to properly cite. Then you avoid plagiarism. So plagiarism here at BCAT is an academic integrity violation. And it's also copyright infringement. If the author finds out, they may come after you. But if you use just a small portion, like a sentence, a paragraph, 2 paragraphs, and you properly cite, it's not violation. You can use it. And that's what we do when we write articles, when we write books, etc. Okay? Well, this we already know. Employers, they are, or they may be vicariously liable for copyright infringement. As an employee of BCAT, if I download illegal content to this PC, BCAT may be vicariously liable if I do this in the course of work. We already know this. Some exceptions here, other exceptions I just mentioned to you, attributed quotations. So when you make quotations, but you cannot quote the whole book. No, you have to quote whatever is needed, but not everything. So if you are the holder of a copyright and you need to enforce your rights, so you have written an article and now someone else is claiming to be the author of your article, what can you do? So you can go to court for injunction, stop order, so that they stop using. This injunction could be interlocutory or permanent. Interlocutory would be before the trial, permanent after the trial. You could also sue for damages. You may have suffered damages because people would pay to download your article, but now someone is distributing freely, you have lost money. And there's this new order here. We haven't seen this before. It is called Anton Pillar order. And there will be a question in your final exam about Anton Pillar order. What is this order to? What is the objective? The objective is to seize the content that is in violation. So the court is seizing, is freezing the content that is in violation. So let me give you an example. So I know Jamil has illegal files in the laptop. If I sue Jamil, when Jamil gets the notice of civil claim, if I were you, I would destroy my laptop. I would destroy my STD, my HDD. But with an Anton Pillar order, when you are notified about the lawsuit, your laptop is seized. So the material that is in violation is kept for evidence purpose. Does it make sense? So that's what the Anton pillar order is. Service providers, they can also be sued. In other words, YouTube may be sued, Vimeo may be sued, any other service providers, as long as they have not acted to protect your copyright. So let's say you have a song belongs to you, and then someone is playing your song on their YouTube channel. Can you sue YouTube right away? No, you can't. First, you will notify. First, you will get in touch with YouTube. Hey, this belongs to me. This is in violation. If YouTube fails to comply with your request, then you may be able to sue YouTube. Okay, so they may be sued. Something else I would share here is, maybe you have heard about this. There may be other companies, but there's one company I know, they're based in Montreal, Quebec, and they are able to know who downloaded or who watched something illegally online. And then they reach out to your internet service provider, TELUS, Rogers, Shaw, any other, and they know who you are because they can track your IP, the IP that watched it or downloaded that illegal content. So they send a notice, an offer for settlement. They say, hey, if you pay $200 or $300, if I'm not mistaken, we'll settle this. If you don't pay, we will refer this issue to our legal department. Is it legal to demand for this $200 or $300? What do you think? Yes? Do you agree? Sorry?
It's blackmail.
Why do you think it's blackmail?
If they act under the law.
Yeah, so they know that you or someone in your IP downloaded something illegally. So they know you acted or someone under your IP acted illegally. So I don't see this as a blackmail because they are able to, that file or whatever you watch it, you could not have watched it. You violated the law or someone with your IP. So I don't see this as a blackmail. I see this as trying to solve a situation. Because you did something wrong or someone with your IP did something wrong. You downloaded a song from Justin Bieber and you could not. So when they send you a notice, they have records, they have proof that you did or someone under your IP did it. So it's not blackmail. Blackmail is when you use illegal tools to get a benefit. They are not using illegal tools. They have the right. They have the right to notify. They have the right to know who the IP address owner is, etc. Okay, so yes, they can do it. My experience, I have never seen an individual being prosecuted or even being sued in Canada. I have never, but chances are there may be many, and I don't know. But there's the example of Napster guy in the US. Napster guy was arrested because of continuous violation of IP, of copyright. So yes, violation of copyrights may, let me change. Whoever violates copyright may have to pay damages and also may spend some time in jail. Okay, depending on how serious the offense is. So copyright owners, they have both civil remedies, but they also have criminal remedies. Okay. All right, so now question to you. Is IP law federal or provincial? Federal. So A is wrong. Are computer programs, software, copyrightable or not?
Yes.
Yes, they are. I mentioned computer programs are protected by copyright. So not, this is wrong. Copyright protection, only when copyright is registered. Is registration required? No, protection is automatic. Registration is optional. Employer owns the copyright when the employee creates something in the course of employment, except if there's an agreement to the contrary. This is right. This is the right statement. Copyright is protected by statute. Copyright statute. Are we good? All right, so now patent. What is this? Have you played with this when you were a child? Lego? So you played with Lego. So Lego was a patent. The patent was filed July 28, 1958. So here's the first information, the first difference between patent and copyright. The first difference is that a patent, you have to file for, you have to apply for. And you apply for a patent. Your patent application may be granted or may be denied. So if you don't follow the law requirements, your patent is denied. If you follow, the patent may be granted. So that's the first difference. What is a patent about? Patent is about a discovery, an invention. Think about drugs, pharmaceutical drugs, vaccines. They are discovered, they are created. So those are subject of patent protection, not copyright. Your phone touch screen is patentable. Actually, Apple owns the patent for touch screen. Apple sued Samsung in the US and they won over $500 million in damages over Samsung in this dispute. So those are examples of patent discoveries, creations, and you have to file for, you have to apply for. And your invention, when you invent or create something, your invention, you have to prove when you apply that no one has a patent for it. That is new. No one has a patent. That it's an original creation or invention of the inventor. You are not copying anything. It's unique, distinguishable, useful. It has to have a use. And it has to be possible to be built. In other words, when you apply for a patent, you have to disclose how to get to your invention, how to get to your creation, the step by step. This is the requirement of disclosure. Because after the patent goes into public domain, based on your disclosure, others may be able to manufacture. So what the law is saying is, hey, tell me how to get to your discovery. And I will give you some time of protection, exclusive rights. After some time, anyone can manufacture it. So again, encouraging the free flow of ideas, right? And benefiting population, at least theoretically, benefiting the population. Right. Theories, concepts, obvious improvements, they are not patentable. So accounting concepts, for example, they cannot be patented. It's following the law. And theories, the first law of Newton, second law, those cannot be patented. Not scientific principles, not computer programs in Canada. There are some countries actually that are allowing computer programs to be patented. But this is more detailed. This is something new for the last 20 years, I would say so. So I won't touch upon this. Some countries allow, others do not. Canada does not allow computer programs to be patented. We just learned computer programs will be protected by copyright. But I'm just mentioning for the records. Business methods. So business methods, they can now be patented in Canada. They could not before. They can now be patented because of the Amazon case. So Amazon has one business method that they have patented. What is this? The one-click purchase. Do you know what the one-click purchase is from Amazon? Have you used it before?
Buy now,
Sorry?
it's just buy now button.
It's not the buy now, it's actually when you click it, I'm not sure if it's written buy now or not, but when you click it, because Amazon is storing your personal information, your name, your shipping address, and your credit card details, you click only once because they store this information under cookies. So when you click once, the purchase is made. You don't need to go through 1, 2, 3 steps. Confirm this, confirm that, etc. So this is a business method. I told you that patents, copyright, trademarks, etc., they are protected only nationally, only in the country. So Amazon, they applied for a patent in the US for this one-click purchase, and they were granted. Then they came to Canada and made the same application. Here in Canada, this application was denied. Because the law at that time said that business methods cannot be patentable. Sorry, cannot be patented. But then Amazon took the patent office to court and they won the case. So now based on case law, business methods can be patented in Canada too. Okay, can you find the one purchase click there? You can Google later on, but it's based on cookies. So the cookies say you allow cookies in your computer, and then the cookies will save your personal information. This is subject matter of a patent for Amazon. I told you initially that you apply for, and then it will be granted or not. And now protection. Protection is for 20 years. How long is copyright protected for?
30.
How long?
70.
70
Plus the age of.
plus the age of the authors. So 70 after the author's death. Patent 20 years after application. So let's get back here. Filed 1958. 1978. Public domain. Any other companies can now manufacture Lego. The piece. They cannot use the name, but can manufacture the piece, the plastic piece. Now, have you ever purchased prescription medicine in Canada? Have you ever gone to the pharmacy and purchased prescription? Have you heard the question from the pharmacist? Do you want the brand name or the generics? Have you heard this? What are the generics? The generics are patents that are in public domain now, that have expired, that other manufacturers can manufacture. The brand name can only be sold by the patent owner because they hold the brand. It's like Lego. Lego can sell these pieces under Lego trademark because they own the trademark. But any other companies can sell these pieces under a different name. The same applies for prescription. So next time you have your family member and you go to a pharmacy for a prescription, after the pharmacy makes a question and you take your choice and they go there prepare the medicine for you, give a lesson to your family member. Tell them what this generics or branded means. Okay, explain to them. So that's about patent. So that is patent. Question for you. C. Besides the other provisions, the inventor must show the invention was not known or used by any person before they invented it. Yes. New, no one else patented. Original, unique, distinguishable. That's C. C is the right answer. All other wrong statements. The inventor's expression of idea is automatically protected. No, not automatically. Patent will be protected by application and granting. Patent Act allows patent for someone for an existing process. No, if it's existing, cannot be patented. Inventor does not have to send specifications. Yes, they do. They have to fully disclose what their invention is. If a patent is denied, they can apply for a trademark. No, patent is one thing, trademark is another thing. So until now, we learned about copyright, literary works, music works, dramatic works, etc. And we learned about patents, invention, discoveries. We're now moving to trademark. You have a question?
Yeah. For the 20 years, a patent can be shared with another company?
You can share on a business level. So you can sell, you can license, because you created. So like Apple, they have the touch screen patent. Yes, many other smartphone manufacturers, they are using the patent for the touch screen, but they are paying royalties to Apple. So Apple is making money. That's why Apple was awarded about $500 million, a little more than $500 million, based on the use of their patent without paying fees. Okay, and that's the beauty of patent. Again, imagine if you were, I'm not sure, I think there is, you know, the can opener for a soft drink, the mechanism. So I think this was a subject matter of a patent in the very past. Imagine if you were the inventor, could you manufacture everything for the world consumption? No, you cannot, it's just impossible. So you would license, you would sell, and you would get paid royalties worldwide. Okay, but again, because patent is protected only nationally, you would need to patent worldwide as well. Okay. Now, trademark. Tim Hortons is an example. So I know you're drinking Tim Hortons. Why? Because of the trademark. I know your laptop is from Apple. Why? Because of the trademark. So trademark could be any term, symbols, designs, sounds, even colors that will identify product, company, or service. Okay, I know you have an HP laptop. I'm seeing it from here. So the logo is identifying your product. You see there's an R here, R. This R can only be used if the trademark is registered. So copyright is protected automatically. Patent you have to apply for, it has to be granted. Trademark, you apply for a trademark, but the process is not as complex as a patent. They just check if there's a similar name or similar logo design that would make people confused. If not, they will allow the trademark. Okay, so the R can only be used if you have a registered trademark, because it may be the case I have a famous brand, let's say my initials JM, it's a famous brand, but I have not registered it for whatever reasons. So I cannot use the R. I may have my logo, the JM, nice one, but I cannot use the R if it's not registered trademark. Okay. The purpose is to protect consumers from deception. So if I don't like Tim Hortons, and if I see you coming to me with 2 cups of Tim Hortons, one to give me, I already know that I don't like it from far away. So before you get to me, I'm already thinking about an excuse, okay? Because I know from far away, I won't be deceived. Protection is for 10 years. 10 years. However, you can renew protection indefinitely. Every 10 years you can renew. You pay a fee to the trademark office. You are active in business because you have to be active in business. If you are out of business, then you lose protection. you keep the trademark forever. That's why now there's the branded and the generics. The branded, because they own the brand. The generics they cannot use. Tylenol. Tylenol is a famous brand, but several of their drugs, they are sold by other companies as generics or under their own names because they cannot use Tylenol. Okay, so 10 years, but renewed indefinitely. Domain names. So www.bcat.ci. What if I register a domain name as www as bcatcourses.ci? And I will try to pretend I am BCAT. I'm a branch of BCAT. So BCAT, because they own the brand BCAT, they would fight against me for the domain name based on trademark law. They would prove that they own the trademark. So they would get the domain name for them. What else? Well, you may lose your trademark even if you registered it. You may lose if you are out of business. For some reasons, you decided not to be active in business. Or one example is when a company starts, they have a logo, they go out there and register, but then the company is not successful. So the owner or the shareholders decide to shut down the company. But the trademark is still registered. In this case, they will lose their rights. Remedies, the same as for copyright infringement. Injunctions, damages, Anton pillar order, accounting, etc. Now, passing off, this is just a review. We saw this in chapter 4. Well, passing off is a tort law action. Passing off is used by brand owners that have not registered their trademarks. So my example again, I have a brand that is JM, my initials, but it's not a registered trademark. If someone else tries to use JM, pretending it's me or it's affiliated with me, because I don't have a registered trademark, I cannot sue them for trademark infringement. But I can sue them for the tort of passing off. Okay? The remedies under the Trademark Act, they are much better, but still, common law courts, they allow protection for famous brands that are not registered. Question. Which one is false? C, if you have a registered trademark, but you fail to use it, will you lose? Yes, you will. You will lose. So yes, C is the false statement, is the wrong statement, because it's saying protection will not be lost. Yes, it will. So a registered trademark is effective, has legal effectiveness as long as you are active in business. If not, people could register trademarks just in a way to prevent others from using, and they would not be in business. Okay, so that's why another requirement is to be active in business. You have to be in business. All other statements are true here. Now, industrial design. So this different, unique shape. Industrial design is when the pattern, the shape is unique. We're talking about how attractive, how distinctive the shape is. Okay. And then this can be protected for 10 years. 5 + 5. You are initially protected for 5 years, and then you can renew only once. Trademarks, you can renew indefinitely. Industrial design, you renew once. So let's think about chairs, let's think about anything in which the shape, the design is unique. You can get protection under that. So that's industrial design. And now let's think about Apple. And by the way, disclaimer, I'm not sponsored by Apple, but I just want to give you an example. Is there copyright here, protection in this smartphone? Where? Design cannot be protected by copyright.
Oh, the software.
Software, yes. What else? Software, the operating system software, the manuals, the user's manual, so they are protected by copyright. They are protected for over 70 years. Is there a patent here?
Yeah, yes.
Yes, at least one we know, touch screen. There may be others that we don't know. Is there a logo, trademark? So you see, one single product is protected by copyright, patent, trademark. Potentially industrial design, I don't know if there was a design here. So you see how it works? That's why it's important to know the different types of IP. Because you cannot say the iPhone is patented. No, the iPhone is not patented. Some of the components are patented, not the phone. The phone is protected by different IPs. Does it make sense? It's important to know the difference. What protects what? Okay. All right. Now, well, we just integrate the circuit topography with the chips, but I don't go through the chips. Now, confidential information. Well, what is confidential information? Confidential information is any information that is disclosed under confidence. How is information disclosed under confidence? Well, the discloser has to inform that whatever they will disclose will be under confidence. Then it makes information confidential. So if you are the recipient of confidential information, you have a duty not to disclose. And if you cause damage, losses to the discloser, you may have to pay damages, or you may suffer other civil consequences. Okay, I have access to some of your confidential information. I have access to your registration number, to your full names, to your personal email eventually, if you have added a BCAT's system. So I have a duty not to disclose, right? Now, trade secret. Trade secret is a type of confidential information, is a type of confidential information that gives competitive advantage. What is the most famous trade secret for you? Or what is a famous trade secret for you? I have mine. What is it for you? What is a trade secret you can think of? Famous one.
KFC recipe.
KFC sauce recipe? I don't like KFC and I don't like people who like KFC. No, I don't like that. No, I'm kidding. But yeah, KFC recipe. It's a trade secret. It's not a patent. For me, it's Coke, Coca-Cola. So the Coke syrup, I'm a Coca-Cola addict. So that is a trade secret. Imagine if Coca-Cola had applied for a patent back in the 90s, early 19th century. After 20 years, it would have been expired. Any other manufacturers could manufacture Coca-Cola if that were the case. But they have decided to keep it as a secret. Now, the important information. There's no proprietary right in the information. In other words, Coca-Cola, they do not own the formula. Their advantage is because they keep it a secret. In other words, if Pepsi had managed using technological means, any other legal means, to find out exactly how Coca-Cola is made, Pepsi would not be in breach. Because no one owns the trade secret. Their advantage is because they keep it as secret. Keep that in mind. This is very important. I know I read once that Coca-Cola would keep their formula in a vault in a bank in Georgia. Only 2 people would know the formula at any given time. They would never travel in the same airplane. So those are practices, steps to protect the trade secret. And we can certainly say that Coca-Cola has been successful. KFC has been successful too, and others. Right? So the duty here, or the advantage, is to keep it secret. So if you have an invention, you will either keep it as a secret or apply for a patent. If you apply for a patent and it's granted, you have up to 20 years to explore it in an exclusive basis. After 20 years, everyone can do it. If you keep it as a secret, it could be that in 2 years, using artificial intelligence, labs, etc., they could find out how to make your product. So you lose protection. Or it could be the case as KFC. You could keep the trade secret for decades, for years. So that's the choice you make. Okay, that's trade secret. Now, ending with private information. So privacy, by the way, those 2 topics today, intellectual property, there are graduate programs that last for 1 year or even more, just about intellectual property. So what I'm sharing with you is the very, very basics of it. And also privacy. Privacy is a very hot topic nowadays, and you could spend 1 year, 1 whole year, studying only privacy. So I'm just sharing the very little with you. And the very little with regards to privacy is whoever, could be a company, an institution, a person, whoever holds private information, they have an obligation to keep it safe. They have an obligation to disclose the reason. Why are they collecting information? They have the obligation to get consent. So I need your private information for registration purposes. This is what VCAT would say to you. You have to say yes, you have to consent. And if there's any breach of private information, the institution, the person, the company, they have to inform governmental authorities. Have you read in the news about breaches lately? Those
Facebook one.
which one?
Facebook one.
Facebook. In Canada, we had CRA, we had Life Labs, and many other countries. How do we know? Because government authorities, they have to be notified. And also, people who are affected, they have to be notified as well. Okay, so that they can get protected. My wife last year, if I'm not mistaken. Yeah, or early this year, there's a financial corporation in printing statements, sending information for the statements to be printed. Information was breached. So they informed my wife, and they have even offered her 1 year identity theft protection, because criminals, they could use information that was breached for their own benefit. Okay, so whoever has access to private information will have these obligations. All right, so that's what I wanted to share with you regarding to ID. Questions? Comments? Are you ready to file for your patent protection?